Hi, I'm Stephen Koprince, Managing Partner of Koprince Law, LLC. And today I want to talk about a recent SBA case in which shared ownership in 8 companies caused an affiliation problem. Individuals who had common investments in 8 different companies were treated as a single person in this case for purposes of the SBA's affiliation rules. The aggregation of those interests by the SBA cost one company a small business set-aside contract. In a recent decision, the SBA's Office of Hearings and Appeals explained how this little understood common investments affiliation rule works. In so doing, the SBA Office of Hearings and Appeals provided an important warning to business owners who may not realize that affiliation under the SBA's rules can arise from common investments in multiple entities. OHA's decision, OHA's the Office of Hearings and Appeals, the decision is called Size Appeal of 10X Aerospace LLC. If you want to look it up, the docket number is SBA number SIZ 5701. This solicitation involved an FBI procurement for the lease of a Gulfstream 550 aircraft. The solicitation was issued as a total small business set-aside. After evaluating competitive proposals, the FBI awarded the contract to 10X Aerospace LLC. An unsuccessful competitor then filed an SBA size protest, challenging 10X's small business eligibility. The size protest went to the SBA area office, which determined that 10X was majority owned by a holding company. The holding company, in turn, was majority owned by a single individual. In OHA's decision, this individual's name is redacted. He or she is simply referred to as Investor 1 throughout the opinion. Because Investor 1 controlled the holding company, he or she was found to control 10X through the indirect control of the holding company. The SBA area office then found that Investor 1 had invested in 8 other companies with his or her brother-in-law, called Investor 4 in this decision. 2 of these companies were 10X Heritage LLC and another company called the Vineyards of Brandon LLC. Although Investor 1 and Investor 4 apparently each owned less than 50% of Heritage and Vineyards, respectively, the SBA area office aggregated their interests under the Common Investments Rule. The Common Investments Rule provides that, quote, individuals or firms with common investments may be treated as one party with their interests aggregated, end quote, for purposes of the SBA's affiliation analysis. After aggregating the interests of investors 1 and 4, the SBA area office concluded that the 2 investors owned more than 50% of both Heritage and Vineyards. Now, because Investor 1 controlled 10X, and because Investor 1 also controlled Heritage and Vineyards, thanks to the aggregation of interests with Investor 4, the SBA area office found 10X to be affiliated with Heritage and Vineyards. The resulting affiliation caused 10X to be ineligible for that FBI set-aside contract. Well, 10X didn't like this ruling and filed a size appeal with SBA Office of Hearings and Appeals. 10X argued, in part, that it shouldn't have been found affiliated with Heritage and Vineyards under the Common Investments Affiliation. In evaluating the case, OHA explained that where there's an identity of interest based on common investments, the presumption is that the investors have a common purpose, such that their interests should be aggregated. That's the purpose of the rules, to find folks who have common investments, they have a common economic purpose is the idea, so the interests are aggregated. Now, the Common Investments Rule does not apply to all investments. According to OHA, it only applies to those that are substantial, either in the number of total investments or in the total value of those investments. Now, in this case, OHA concluded that because investors 1 and 4 shared common investments in 8 different firms, the SBA area office had not made a mistake by applying that Common Investments Affiliation Rule and aggregating their interests. In other words, the 8 firms, the 8 common investments were substantial in OHA's eyes. Some of the SBA's affiliation rules are intuitive. For example, most contractors, most small businesses understand intuitively that if a single individual owns 100% of Company A and 100% of Company B, well, those 2 companies are affiliated. But common investments affiliation is not necessarily intuitive. It can trip up even savvy contractors. The 10X Aerospace size appeal offers an important primer on what the Common Investments Rule is and how it works. Most importantly, it offers an opportunity for those who might be at risk of this type of affiliation to take action before a size protest comes.